Okay, flock either is or is not a violation of the Fourth Amendment. And when I say flock, what I mean is, of course, law enforcement use of flock to conduct research about people's movements along the freeways and roads of our communities. Is that a Fourth Amendment violation or is it not? I would have kind of thought not initially, just sort of based on my feeling that it's a third party type issue. But there's been a lot of discourse in the public around this question in the last couple of weeks. And to some extent, I feel like the public is onto something. And there is a line of authority related to cell phones and cell phone location data that goes right to this question of whether flocks or the use of flock could potentially implicate the Fourth Amendment. And so I want to talk about it a little bit just at a real high level. And this is not intended for lawyers necessarily so much as it's intended for regular folks who think law is kind of interesting and are maybe somewhat concerned around the proliferation of this network of surveillance cameras. Um, so let me, oh, and I wanted to say, by the way, my intention here is to go what I'm thinking of as Kombucha Girl on this subject. And Kombucha Girl is the famous meme of the girl who tries the kombucha and she's like, oh, that's terrible. And then she's like, well on the other hand, and that's kind of my thought process around this whole legal question. Like, on the one hand, no way. But on the other hand, maybe there is a Fourth Amendment issue here. The Fourth Amendment, first of all, the text of the Fourth Amendment refers to unreasonable searches and seizures, and it refers to certain physical things like effects and papers and so forth. Most folks know the Fourth Amendment applies to the government. Okay, it doesn't restrict the actions of private actors like Flock, like ShotSpotter, like cell phone providers, and so forth. Nevertheless, when law enforcement um, dips its fingers into networks of information or databases of information that are accumulated by these private actors, sometimes it can implicate the Fourth Amendment. And one thing that I think is notable about Flock is that although we're having a bit of a cultural moment where people are flipping out about Flock, and perhaps justifiably so, it's hardly the only aspect of our contemporary culture where there is very, very, very broad surveillance. Um, there are more than 10 million Ring doorbells already in existence, installed on people's homes and businesses in some cases. And law enforcement can and does access surveillance footage and audio captured by Ring doorbell cameras, sometimes to investigate crimes. There's, of course, toll roads that capture time and license plate information of the cars that pass through them. There's things like cell phone towers that capture, the phones that access them and when they access them. There are navigation systems built into most of our cars now, at least the more late model cars, and those are constantly collecting and transmitting information about location. There's ShotSpotter. It goes on and on. There's quite a bit of surveillance of contemporary life in many different modalities. And while Flock is interesting and it's really, really, really ubiquitous now, it's just not the only thing. And so, whatever rule applies to Flock, we have to consider that it could potentially apply to these other modalities too. So let me start with I got my bubble water here. It's very important to stay hydrated. It's summertime, by the way. I'm not wearing a coat. It's too hot up here. I don't have air conditioning. Let me start with this idea that flock or the use of flock is not something that implicates the Fourth Amendment. So if we talk about this basic idea that there's not a Fourth Amendment concern related to the use of flock, there's really two threads that support this position. And one is that the cats, well, wait, let me back up. A lot of the jurisprudence in this area stems from this case in 1967 called Katz. And what Katz says is that the Fourth Amendment is going to apply where there's a reasonable expectation of privacy. The word privacy is not in the Fourth Amendment, but Katz kind of brings in the notion of privacy. And so there's got to be subjectively, a person has to expect that they have privacy in some particular setting, and the expectation has to be one that society recognizes as objectively reasonable. And that matters because all kinds of stuff that happens in public doesn't have a reasonable expectation of privacy. And even some things that happen, for example, in the backyard of your own home might not have a reasonable expectation of privacy. And there's a famous case on point where the government flies over and sees marijuana, but from a public vantage point up in the air, sees marijuana. Well, that doesn't implicate the Fourth Amendment because you're putting that out in a place where you don't have a reasonable expectation of privacy. There's also a case called Knott's, and Knott's really kind of matters for this flock analysis. Knott's is a case where there's like a beeper attached to a barrel, and the barrel's put in a car, and that beeper is used to track the movements of the car down the road along public roads. And what the Supreme Court says is that the movements along a public road are exposed to the public. You don't have a reasonable expectation of privacy in that movement. But it matters that Knott's is a situation where the beeper is attached to the barrel, not to the car. So put a pin in that because we'll come back to that. Then the other thread that comes into this whole discussion around why flock is not implicating the Fourth Amendment is what's called the third party doctrine. And the third party doctrine most notably has been held to apply in cases or in situations like transmitting records to a bank or dialing a phone number and having my phone number dialed go through a phone company. I'm transmitting information not to the government, but to some third party, like to some private company. The government can request that or get a subpoena to obtain that information from the third party, particularly with phone records. And that's not something that implicates the Fourth Amendment because it's being transmitted to a third party and you're sort of giving up your expectations of privacy in that. And so here, as it relates to flock, one could argue, look, you're driving down the road, it's a public road, you can't possibly think you have a reasonable expectation of privacy when you're out on the freeway. You can be seen by literally thousands of people. And your location information is being transmitted to a third party, which is Flock, which is a private company. So therefore, if the government comes along later and accesses that information from the third party, tough luck. You didn't have a reasonable expectation of privacy in the first place, and the information was collected by a third party, so you're out of luck. Okay, that's the position I think most courts have taken so far in this area. But hold on a minute, because there's also a line of authority that comes out of, particularly out of cell phones, but not only out of cell phones, because there's also a case called Jones in 2012 that is another one of these tracking a vehicle cases, and it goes a different way than the Knott's case had gone. And what Jones involves is putting a GPS tracker on the bumper of a car without a valid warrant, and then collecting a bunch of data about the movements of that car for like a whole month. And Jones concludes that does implicate the Fourth Amendment. And there's a really interesting discussion of it from Justice Sotomayor, where she says, as it relates to the third party doctrine, she says it may be necessary to reconsider the premise that an individual has no reasonable expectation of privacy in information voluntarily disclosed to third parties. This approach is ill-suited to the digital age in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks. And so that Jones decision, I would say, is the first kind of indication that maybe the third party doctrine doesn't hold with full weight when it comes to the collection of large amounts of digital information about people's whereabouts. Okay. And then moving along from Jones, we get to the Carpenter case, and Carpenter's a case that concludes that a warrant is necessary to collect cell site information. In other words, the information about what phones, or what cell towers an individual's phone connects to. And there again, you might think, well, that's a third-party doctrine issue. It's not the government's cell tower, it's some private company's cell tower, so why does it matter? But Justice Roberts, who writes the majority opinion in Carpenter, says, he says a lot of really interesting things, but one of the things he says is, few could have imagined a society in which a phone goes wherever its owner goes, conveying to the wireless carrier not just dialed digits, but a detailed and comprehensive record of the person's movements. And Justice Roberts goes on to say, essentially, we have in these cell site location information records are just a very, very detailed sort of diary of everything a person does, essentially, and that's qualitatively different than just tracking an individual's movements down a road one time, say, as in that earlier case that I discussed. Justice Alito in Carpenter, and I discussed this a little bit in an earlier video, but Justice Alito kind of flags like, hey, the erosion of the third-party doctrine as it relates to digital surveillance is really a Pandora's box. He says, we can guess where today's decision will lead. One possibility is that the broad principles that the court seems to embrace will be applied across the board. And, he feels like that's extraordinarily problematic. And then we get in just this year to this case called Chattree, which is about geofencing. And geofencing, again, is this notion of identifying all phones that connect to a particular cell tower in a particular area, a particular time, as a sort of way of drawing a digital fence around everybody who was in that vicinity for the purposes of identifying people who may be suspects in a crime. And there again, the Supreme Court concludes that that does raise Fourth Amendment concerns, even though there's that third-party doctrine type idea. Digital information that has that kind of granularity is just more, it's just different. It's just qualitatively different. So if you kind of take all those, or that line of cases together, from Carpenter to Chattree, and then we think about how maybe it relates to Flock, if you're going to make the argument that Flock is, or that the accessing of Flock data is a violation of the Fourth Amendment, I think there's a couple pieces of the puzzle that matter. First of all, Flock systems are typically installed pursuant to a contract with a government, whether it's a municipal government of some sort or whatever. They don't just get installed for fun. They get installed because some government agency is paying them to install these devices, and the whole purpose of installing the devices is to anticipate the need to respond to criminal investigations. So there is, it's true, it's a private company, but it's a private company that's acting at the behest of, and specifically for, a government agency. So that's one aspect of it. The other aspect of it is this extraordinary granularity. Much like in Chattree and in Carpenter, Flock systems are accumulating data about essentially individuals' movements everywhere they go, all the time. And that's not like pursuing one barrel of chemicals down a road once when there's already a specific focus on that individual. It's just casting a very, very broad net around all of society generally, collecting all the information about everybody, and then querying it after the fact to find out, what somebody might have done wrong. And so I guess the question would be, do those distinctions make a difference? And could a court meaningfully carve out a rule in which the Fourth Amendment applies to the use of Flock databases without also, say, invalidating every search of a Ring camera, or without invalidating every use of ShotSpotter, or these other broad databases that are based on surveillance that I mentioned at the start. So there's really complicated issues related to that. And I guess the main point I wanted to emphasize is just that it's not necessarily a slam dunk one way or the other. I mean, I think at one point it would have been a slam dunk because of the third party doctrine. But as I say, in this line of cases that involve Carpenter and Chatry, and even Jones, where the surveillance starts to become more pervasive and where it starts to paint a detailed minute by minute picture of individual movement, not just over a few hours or a day, but over essentially all of time, the Supreme Court has been more willing to say that the third party doctrine and this notion that whatever's in public is fair game can start to potentially not be the case. And so we'll see how this all plays out. I think this is kind of a brave new world of technology, and it's also a brave new world of Fourth Amendment jurisprudence. Hopefully that's helpful to some folks just as a way of thinking about all this stuff. And see you next time. Stay cool.